You may be seated. Thank you. Good morning to you all. We're going to have to speak pretty loud today, loudly, and I think we must proceed forthwith. It's 11 o'clock, and I think we'll take the tea adjournment at 12. Advocate Hasan.
Thank you, Justice. Justice, before I begin, I'll point out the time, and in light of the discussion we had this morning, that we're an hour and a half behind my allocated time, and if I may continue after the lunch adjournment.
Yes.
Thank you for your indulgence this morning.
After the tea adjournment.
After the tea adjournment.
11 to 12, and yeah.
Yes.
Okay.
Justice, I'd like to thank you for your indulgence this morning and for the facilitation of discussion between the parties. I'm glad to be able to place on record that an agreement has been reached between the state and Section 27.
Just a minute, I think. Viewer, you gave me a pen that's run out. Engos. Yes, Counsel.
An agreement between the state and Section 27 as follows. In respect of Claim A, which is funeral expenses, the agreement is that 20,000 rand will be paid to each claimant. In respect of Claim B, which is the common law claim for emotional shock and psychological injury, the amount that has been agreed upon is 180,000 rand per claimant. In respect of Claim D, which is the claim in relation to counselling, that counselling will be provided to the families as required. In respect of Claim C, which is the claim for constitutional damages, we were unable to reach agreement. In the light of the settlement on Claims A, B, and D, I will focus my address to you on constitutional damages.
Advocate Krause, do you confirm the terms of the agreement in relation to these heads of damages?
Justice, unfortunately, we have been unable to reach any agreement in respect of general damages. No offer was made in respect of counselling as yet. But we are continuously taking instructions, and we will place on record if we reach an agreement at any stage.
So you're not part of any of this arrangement?
Unfortunately not, Justice.
Very well. Advocate Groenewald.
Thank you, Justice. Justice, I can confirm that after deliberating with my colleagues from the state again, my apologies, we have reached agreement to settle our common law damages in the amount of 200,000 rand for each family member. So that will include the amount for funeral expenses as well as emotional shock. In respect of the claims for counselling.
So in essence, it's 180 plus 20.
Indeed so, Justice.
Yes.
In respect of counselling, we haven't settled or discussed that with my colleague, but I am assured that we will be able to communicate settlements in respect of that claim specifically. We've claimed exactly the same as Section 27 in respect of counselling, so I do not see or foresee any problems, but I'll need to clarify that with my colleague.
Very well. Advocate Mutama.
Good morning, Justice.
Good morning.
It is indeed correct that an agreement has been reached with Section 27 on behalf of their clients on the terms that have been recorded in the total amount of 200,000 for each family. With the claimants represented by Hatter Spears Incorporated, we can also confirm that an agreement has been concluded and the total amount agreed on is 200,000. And I should also indicate that the issue relating to counseling is a matter which will also be offered to the claimants in this regard. And the remaining issues or issue that has to be determined is that one of constitutional damages sought by claimants represented by both Section 27 and Hatter Spears. It is indeed correct that with regard to claimants represented by Legal Aid South Africa, no agreement has been reached yet. We'll await to hear from them. And I should place it on record that on the last communication with Legal Aid, an offer relating to counseling has been made to them. That offer has been made to them. So we will expect to hear from them in relation to all those aspects that have been offered to them. And obviously, on the issue of constitutional damages, we do not anticipate to reach any common ground on that, and then argument will be presented.
Very well.
And while I'm still on the if I can just be given an opportunity to report one matter which was outstanding from the last sitting in relation to the list which had to be verified of the people who had to be included in these proceedings. We would like to report that we have indeed managed to get the assistance of the Office of the Ombudsman, who helped to verify the list which was submitted by Section 27, the list of 12 which was debated on the last occasion. And from the report which we have and which has been circulated to all the other parties, do confirm that out of the 12 names, it is only one person, or it is only one claimant who qualifies to be included in the arbitration process. And on that basis, I beg leave to hand up a copy of the report which gives detail of how the verification was conducted to exclude the 11 names from these proceedings.
As a consequence of the report, what on the state's version is the total tally of mental health care users who passed on?
Justice, if we add 143 plus 1, it will give us the total of 144.
Yes, thank you. A copy of the report will be made available to me, will it?
Indeed so.
And that will be Ella.
Justice, if we can head it up later to verify the sequence of the Ella number so that it can be appropriately marked. In the meantime, I should indicate that the report has been circulated to all the parties, and we just wanted to place that on record before we proceed.
Yes, very well, thank you. Counsel, is there anything you have to say about the verification process?
Justice, I'd prefer to say as little as possible. We are not contesting the report of the Ombudsman. We have amended our Annexure A in the light of the report of the Ombudsman. And we'd like to hand that up and circulate that to the other parties, if we may.
Yes. Thank you. And in relation to missing persons, is there any number other than the one presented by the MEC? Dr. Ramokhupa.
We rely on the number presented by the MEC, Justice. We're not aware of any developments in that regard.
I saw that in your heads, but there's no contestation now about the number of people outstanding, is there? No.
In terms of the missing persons?
Missing persons, yes.
There is no contestation on
Yeah,
that.
very well. Thank you. Just before you go ahead, also, at some point, Advocate Krauser, you're going to give me a schedule, are you?
Yes, Justice.
Yes.
We have attached one to our heads of argument, but we will make sure that it is in order when we argue.
Yes. That is final.
Yes.
I've seen that, and I don't know whether it's preliminary or final, but very well.
Thank you, Justice.
None of the parties has said anything about the contemplated memorial in the terms of reference. And at some point, when the discussions are moving on, we have to talk about that. And so too the specificity around the counseling, i.e. the institutions. There should be sufficient detail to be able to identify the institutions and the frequency of the counseling. That's going to be important if you have regard to the detail required for the award itself. So I just want to remind the parties that it's going to be important in the agreement to identify and locate institutions that will be able to provide, or a method that will be able to identify the institutions concerned, and whether or not parties have an agreement about the kind of memorial that will remind us of this tragedy and what order I should make in that regard ultimately. Counsel, I think you may proceed.
Thanks, Justice. On the memorial, there is an agreement between Section 27 and the state. In other words, there's an agreement between the parties and the state that there would be a place of remembrance. It's the detail that we need to work out, and we'll undertake to facilitate the discussions in order to present before the end of the hearing a bit more specificity with regard to that and in relation to the method to be followed for counselling processes.
Yes. But of course, if the agreement is going to be part of the award, it has to be made available before I complete writing up the award.
That is so.
Very well. You may proceed.
Thank you, Justice.
As I understand, the argument then is limited to the legal basis for granting constitutional damages and its quantification.
That is so, Justice. And I propose to go straight to that. Our written submissions obviously deal with the aspects in relation to emotional shock and psychological injury. The only aspect of that which I will still rely upon for the purposes of the argument on constitutional damages is the evidence of Ms. Coralie Trotter. Justice, the outline of my submissions then will be to discuss constitutional damages firstly through the prism of Section 38 of the Constitution and the case law dealing with the meaning of appropriate relief. This will necessitate a discussion of the facts, which will be followed by our submissions on the breaches of the claimant's rights. It will be our submission that common law damages are not sufficient for redress in the extraordinary circumstances of this case, and that direct enforcement of Section 38 is required. In making the submissions in that regard, we will refer to the exposition of constitutional damages by our courts. In particular, we will make reference to the Fosse, Modderklip, and Kate judgments. but we will also make reference to the award of constitutional damages in comparative jurisdictions as set out in our written submissions. I'll thereafter deal with the question of the quantum of the award of constitutional damages, and in that regard I'll make reference to the actuarial report by Mr. Gregory Whitaker. I'll then turn to the question of structural relief. There's some relief that's more structural in nature that is set out at paragraphs 353 to 357 of our written submissions. I don't believe this to be contentious, but I will address it at the tail end of my submissions on relief. And then finally, I'll address the question of costs. Justice, the first principle we submit that emerges from the law on remedies is that just and equitable relief is determined by the facts and circumstances of the case at hand. Section 38 of the Constitution provides that where a right in the Bill of Rights has been infringed, the court may grant appropriate relief. And as Justice Krickler pointed out in the Fawcett judgment, the provision does not provide relief where appropriate. What it says is appropriate relief per se. In other words, what is very important at the outset and as a framework for understanding the remedies that we seek is that the remedy is part and parcel of the right. It's not well established in our common law, that principle. It's expressed in the Latin maxim, ubi jus, ibi remedium. It was referred to, as we know, by St. Lives CJ in Minister of Interior versus Harris. We think that that is an important starting point for understanding the principle of remedies and the relief that we seek.
Yes, where there's a right, there's a remedy.
Indeed.
Or there must be a remedy.
The right would be innovated without a remedy, in other words. The second principle we submit is that the courts have wide and generous remedial jurisdiction. In perhaps the most cited dictum on remedies, the Constitutional Court in Fosse held that appropriate relief means effective relief. And this most often cited dictum is as follows, and I quote, "I have no doubt that this court has a particular duty to ensure that, within the bounds of the Constitution, effective relief be granted for the infringement of any of the rights entrenched in it. In our context, an appropriate remedy must mean an effective remedy, for without effective remedies for breach, the values underlying and the rights entrenched in the Constitution cannot properly be upheld or enhanced. Particularly in a country where so few have the means to enforce their rights through the courts, it is essential that on those occasions when the legal process does establish that an infringement of entrenched right has occurred, it be effectively vindicated. The courts have a particular responsibility in this regard and are obliged to forge new tools and shape innovative remedies if needs be, to achieve this goal." In the same judgment, Justice Frichler considered what the meaning of an appropriate remedy is, and he described it as one that is specially fitted or suitable. And in our written submissions, we make reference to his discussion on what it means to have a remedy that is specially fitted or suitable. And that's at paragraph 97 of the judgment. I don't wish to read the entire passage. It is in our written submissions, except to highlight the following sentence. "The facts surrounding a violation of rights will determine what form of relief is appropriate." Similarly, in Motau, the Constitutional Court held that to grant appropriate relief, the court must determine what is fair and just in the circumstances of the particular case. And in reference to this case, I would like to quote the following passage, which is at paragraph 85 of the Mutau judgment. And it reads as follows: the various interests that might be affected by the remedy should be weighed up. This should at least be guided by the objective to address the wrong occasioned by the infringement, deter future violation, make an order which can be complied with, and which is fair to all who might be affected by the relief. It also goes without saying that the nature of the infringement will provide guidance as to the appropriate relief. So following on Fose, Mutau has set out very neatly the principles that one should bear in mind when determining appropriate relief. It's also our submission that Section 38 is to be read with Section 172, 1b of the Constitution, and that is that the court may make any order that is just and equitable. And our courts have held that this is an expansive remedy that can be used even if there's been no declaration of invalidity. In other words, the bounds of the remedy that a court may impose is restricted only by what is just and equitable. We've referred to the relevant case law in our written submissions, and I don't wish to repeat my submissions now. What we would like to say is that the arbitrator's terms of reference, the jurisdiction of the arbitrator, which is contained in the terms of reference, specifically paragraph 6 of the terms of reference, mirrors the broad nature of the court's powers when confronted with a violation of constitutional rights. So these principles tell us that the nature of the infringement of rights, the facts of a particular case, and the need to address the wrong are all relevant to what would be appropriate relief.
Well, it occurred to me that when one looks at the arbitration agreement, the terms are couched in full anticipation of equitable redress. So if one for a moment were to forget Section 38, read with Section 172(1), God forbid, we should never forget them. Assuming we set them aside for a moment, isn't there a pre-existing agreement between the parties on the kind of relief that the arbitrator ought to utilize? It's equitable redress, and paragraph 6, the point you just made, seems to guide us and tell us you're going to have to find equitable redress here. In other words, is it fair to say the parties anticipated that there will be equitable redress? And is that sufficient jurisdictional fact on its own?
We would submit that it is. The section, paragraph 6 rather, confers a very wide jurisdiction on the arbitrator. And in essence, it's an equity jurisdiction that you preside over in this arbitration, which means that we have entrusted to you the power to award redress that is appropriate, just, effective, equitable in the circumstances. There's some examples, and we've provided guidance as to the kind of relief we seek from the arbitrator, the kind of relief that's not normally awarded by a court of law. That too is an indication of the wideness of your jurisdiction being one of equity.
So the argument that you have no power to grant constitutional damages, how does that stack up against the provisions of paragraph 6?
Well, the argument doesn't stack up with my interpretation of paragraph 6 as I've just presented it to you. It's precisely for the reason of reaching closure and equitable redress, including compensation, that the parties sought to bring this before an arbitrator. To suggest that the power of the arbitrator should be curtailed and that we should be bound by something less than what we would be entitled to get in the court is, with respect, an unreasonable argument.
Yes. Because the essence of the argument would be you are limited to granting common law relief, and that we concede. But you're not entitled to look at the Constitution in order to search for equitable redress, isn't it? That's the essence of...
That is the essence of the argument, and I think that we should make short shrift of that argument. The entire purpose of our presence in these arbitrations has been to vindicate the Constitution. It's been to hear from the families, and we've heard a lot from the families regarding violation of rights. We've heard concessions from the government in relation to the violation of rights. So to reach the point, this stage of the proceedings, in which we're now dealing with the arcana of law, to say that constitutional damages doesn't pertain is an affront, I would say, not just to the families, but to the dignity of these proceedings. I'd also like to point out that constitutional damages, there's a tendency to perceive constitutional damages as something alien and out there and wild. But in fact, the courts have awarded constitutional damages in the past, so it's not something new. The only question before you, Justice, is whether these are appropriate circumstances in which to award constitutional damages, and if so, in what amount. It cannot be that your hands are tied and that you can't look at the availability of constitutional damages as a remedy at all.
Yes. Of course, historically, claims sounding in money, arising particularly from delict, have always been couched in common law terms. And in the transition, isn't it so, when you look at the cases, that the courts have always struggled with that interface?
Yes.
And whether, in fact, there are two separate jurisdictions, two systems of law, or one system of law. Do we have two systems of law? Do we, if you couch your claim in common law terms, would you be denied reliance on constitutional protections?
No, Justice. Pharmaceutical manufacturers has answered that question already. And it was clear in the judgment of Justice Chaskelson at the time that we do not have two bodies of law. We have one system of law in which the common law forms a part. And indeed, the common law may need to be developed and infused with the values of the Constitution, but they are not two separate bodies of law.
And could you non-suit a litigant on the grounds that your claim relies exclusively on rights set out in Chapter 2 of the Constitution? Could you send people packing on the ground that they did not plead an infringement traditionally as one would do in a delict? An act that is unlawful, that is negligent or intentional, and that causes harm. That's the standard definition of delict.
That's correct, Justice. The first thing to be said in that regard is Section 38 makes it clear that one may approach a court or another tribunal for appropriate relief where there's been a violation of rights. The mechanism for doing this is shaped by our history and the vehicle of particularly the Quillian action for claiming a violation, well, for claiming relief under a delictual under delict. And in our written submissions, we set out how that has evolved over time and how emotional shock, for example, as general damages, has come to be included within the framework of the Aquilian action. The fact that a particular framework and mechanism is used does not mean that one cannot, in the context of that framework, include a claim for a violation of rights. In fact, at times, the common law and relief under the common law may include a decision on violation of rights. So if in a particular matter, the claim goes further to say the constitutional rights that have been breached cannot be effectively vindicated through the common law alone, then it's a natural extension to say constitutional damages is the appropriate approach.
Yes. In the Koko, for instance, the argument wasn't it? It was whether or not a defamation claim invokes constitutional protections.
Yes.
And the
it
court
does.
was basically wrestling with that question, whether if you came with a vanilla claim, i.e. a common law claim of defamation, are you entitled to rely on the protections that are also extended by the Constitution?
Indeed, Justice, and one is the mechanism, as I said, is not a bar to, and it links to your first question about whether there are two bodies of law. It answers the question that there are not two bodies of law. And we need to, as I've said, and Carmichael, I think, also dealt with it very, very well in addressing the question of development of the common law in order to bring it in accordance with the values of a democratic South Africa.
Yes. You may proceed. I think I delayed you a bit, but I needed to debate with you something that probably is very fundamental in this particular case. Very well.
I'm indebted, Justice. So,
but before you move away, why do you say the parties in the agreement preferred the phrase equitable redress? And not just compensation? Is there any significance to be drawn therefrom?
I think that it's quite an important phrase that's used in the terms of agreement. And it's intended to confer, as I submitted, Justice, a jurisdiction of equity on the arbitrator. And that is why my references to Section 38 and 172(1)(b are relevant. But my argument is that you may go further. You may do whatever is just and equitable in these circumstances.
Thank you.
I left off before our discussion, Justice, about the centrality of facts and the circumstances of a case to determining what is appropriate relief. And I'd like to go to that now. And the facts of this case all began with the termination of the contract between the Gauteng Department of Health and Life Esidimeni, the decision which was given effect to on 29 September 2015 in a letter to Life Esidimeni providing 6 months' notice of termination. That meant that all of the users, more than 1,700, would have to be moved out of the facilities by 31 March 2016, which was then later extended to 30 June 2016. We were provided with 3 reasons for the termination of the contract by the MEC and by the former MEC, Ms. Mahlangu, and by the former HOD, Dr. Celebano, and others in the hearing. And these 3 reasons were the following. The first, that the Gauteng Department was merely implementing national policy on the deinstitutionalization of mental health care users. The second is that the Auditor General had raised a concern regarding the duration of the contract with Life Esidimeni. And the third was budgetary constraints. There's no particular order of hierarchy in those three reasons. But what we were able to establish by the end of the hearing is that none of these reasons hold water. The argument, the justification of deinstitutionalization was roundly discredited at the hearing. There was no aspect of the Marathon project that was consistent with the national policy, let alone the laws of the land. Mental health care users were not consulted, informed, or prepared for the process of transfer out of Life Esidimeni. Their proxies, the families, were not consulted, informed, and prepared. There was no proper discharge process. The NGOs to which they were moved were in abysmal conditions. Many mental health care users were moved more than once, and many were moved to NGOs far from their family home. All of those factors fly in the face of the national strategic policy, strategic framework on mental health care. Secondly, both Ms. Mahlangu and Dr. Salabano claimed that the reason for the termination related to the need to comply with the Auditor General's requirements concerning evergreen contracts. No evidence was provided to support this ostensible reason. To the contrary, the MEC for Finance, MEC Creasy, testified that despite her search of such evidence, no evidence of that claim could be found. The third reason was resource constraints. But we now know that there were no budget constraints, in fact. The overall budget for health in Gauteng increased in the years before and after the removal of the patients from Life Esidimeni. The contract with Life Esidimeni was cost effective. The department's bank account was a leaky bucket, with many millions of rand being paid to consultants at a time when National Treasury had issued an instruction to curtail spending on consultants. We also know that financial mismanagement was rife, with increasing accruals and significant irregular expenditure, 1.6 billion rand of which was referred to the SIU for investigation during this period. The Provincial Treasury, furthermore, had advised the department not to cut costs on core services. Those are the facts that have emerged from the hearing in relation to the reason that the department faced budget pressure. We also submit in any event that resource constraints can't constitute an acceptable justification for the failure to protect constitutional rights if the department was mistaken in its understanding of its obligations in relation to those rights. And in that regard, we refer you, Justice, to the judgment of the City of Johannesburg versus Blue Moonlight, which is in our written submissions, in which the court stated as follows: "It is not good enough for an organ of state to state that it has not budgeted for something if it should indeed have planned and budgeted for it in the fulfillment of its obligations." Here, the department had previously budgeted for the care of the mental health care users at Life Esidimeni. But under the guise of budget constraints, they cut the level of health services to those mental health care users and the quality of health services that were provided to those mental health care users, resulting in our submission in a negative infringement of the right of access to healthcare services.
Is this a case of the limitation found in the Constitution on fulfillment of a right being subject to available resources?
It is indeed not. We don't even get there. This is not a question of Section 27.2 and the progressive realization of the right. We are dealing squarely with a negative infringement of Section 27.1.
Yeah, nor was it pleaded or suggested by any of the principals.
No.
If anything, they suggested the opposite. We had more than enough money.
That's correct. In the end, Justice, we still don't know why. I've addressed the 3 reasons. I've said that they're not actually reasons we've learnt. They're not the real reasons. In the end, we still don't know why this devastating decision was taken. As if the irrationality of the decision is not bad enough, there was no sense, reason, or responsiveness to be found at any point during which this saga unfolded. What we find instead is disregard, and in some cases contempt, for those who warned of the risks, cruelty, and serial violations of the law, constitutional rights, and obligations. In our written submissions, we set out from page 17 to page 60 the very extraordinary circumstances of these deaths. It's set out with some detail, Justice. I'd like to refer to the key aspects of these facts. And the reason I wish to do so is for the reason I stated at the outset of my address, which is it is inextricably linked to the relief which the claimants seek.
Yes, of course, the more egregious the violations, the more they would attract a need for equitable redress.
That is so.
So the facts remain very relevant.
That is so. The first aspect that we addressed in the written submission was that there were warnings, that the alarm was sounded many times, but was not heeded. And the first written evidence of the raising of the alarm is on 28 April 2015, and we're by now all familiar with this letter from the clinical heads of the Gauteng psychiatric hospitals and head of departments. The letter was addressed to Dr. Manamela and copied to several other officials, in which the clinical heads expressed their concern about the reduction of beds at Life Esidimeni. What the clinical heads noted was that based on available evidence, the decision to reduce beds at Life Esidimeni will, and I quote, in all probability, escalate costs of healthcare delivery in our province rather than reduce them. The clinical heads specifically warned against en masse discharge. And finally, they stated that the decision to reduce beds in Life Esidimeni will have, and I quote, a devastating impact on the health and social well-being of mental health care users, the healthcare system, and members of the community. The response we received from the officials who testified, Dr. Manamela testified, that she advised the clinicians that even though the letter was addressed to her, it should be rather sent to the former MEC and to Dr. Celebano, although he had been copied on that letter, Dr. Celebano. Dr. Celebano testified that he didn't remember receiving the letter, but he did not deny having received it. Former MEC Mahlangu testified that she personally never actioned communications that are sent to her. So the letter may have arrived at her desk, it may not have. She wouldn't know because it's something she leaves to the officials in her department. That was 28 April 2015. On 22 June 2015, the South African Society of Psychiatrists wrote to former MEC Mahlangu. The letter was also copied to officials, both at the national and provincial level. SASOP stated its concerns that the reduction of beds at Life Esidimeni would lead to, in their words, unintended, costly, negative consequences. There was no response to this letter. In October 2015, SASOP addressed another letter to former MEC Mahlangu. The letter was also copied to several officials. Again, SASOP raised its concerns that community mental health services had not been sufficiently developed to accommodate mental health care users. Again, they did not receive a response. On 26 November 2015, the South African Depression and Anxiety Group addressed a letter to the former MEC Mahlangu, Dr. Manamela, and Dr. Salabano, in which they recorded the minutes of a meeting that had taken place between the parties. They sought in this letter an urgent response to a long list of questions. Again, Justice, I think we're all familiar with that letter. The details are set out in our written submissions. But what the letter also showed was that the managers of the state facilities, the facilities that were referred to by former MEC Mahlangu in response to the legislature, confirmed that the state facilities were not able to absorb additional patients. Dr. Manamela testified that she did not respond to the letter as it was addressed to former MEC Mahlangu and Dr. Salabano, as well as to her, meaning she therefore did not have a responsibility to address the concerns or to respond to the authors of the letter. Former MEC Mahlangu testified that she did not remember whether she personally dealt with the SADAG letter sent on 26 November 2015. However, in cross-examination, she conceded that she had in fact responded. And the record shows her response to be as follows, and I quote, "Please get our legal team to get involved in this process. HOD and Dr. Lebete, you have to drive this process to provide leadership. These NGOs are dishonest. Exclamation mark, exclamation mark, exclamation mark. Please treat this as urgent. Exclamation mark, Khedani." In other words, Justice, I anticipated a question from you, but
No.
I'll keep going.
No. It's a little like walking away from a terrible situation and you come back to it and you're bound to be asking, as I do, when you set out the facts as detailed as you do. Truly, what were these public office bearers doing? How do they admittedly just ignore all these attempts to reach them in a variety of means and to choose to see civil society as enemies? And I've been mulling over this and by reading hers and thinking, why would they have taken this position that is so utterly devastating and choose that? Then why would there be this continual pattern of just ignoring letters and emails that are never given attention to or responded to properly, as public officials are duty-bound to? You might have the answer, having worked through the facts.
We can keep working through the facts. I'm not sure I will have an answer for you, Justice. But what it does show is a contempt for civil society. And the salt in the wound is that the same officials testified in these proceedings that they were not prophets. They were not foretellers. How could they have known? They could have known. They would have known if they had listened. Unfortunately, Justice, the warnings didn't end there. we heard evidence from Dr. Mkachwa that, in addition to the warnings by the clinicians and civil society organizations that I've referred to, that he also warned Dr. Salabano of the likely catastrophic results of a haphazard relocation. He was unable to persuade his colleague in the health profession to stop the course of action. And when it became clear that the plan was moving ahead, Dr. Mkachwa then offered for Life Esidimeni to help train the NGOs. And that offer was refused. On 22nd September 2016, Section 27 wrote to Ms. Dumi Masondo, the chairperson of the Mental Health Review Board. Ms. Masondo, too, was warned in her very special capacity as an independent custodian of the rights of mental health care users.
She chooses to be completely ignorant of her statutory duties, but happily takes home what? 30,000 rand or more a month, every single month, and never raises a finger to protect these patients. I mean, what were these officials smoking? I mean, what were they doing? She has a job with statutory duties set out painstakingly, and she gets paid every month and chooses to look away. I know what you make of that, but I mean, that still bothers me so deeply.
It is clear that she did choose to look away. And unfortunately, Mrs. Masondo exhibited the same disposition towards civil society. So this letter on 22nd September, Mrs. Masondo denied receiving the letter that was sent to her. Although she confirmed her email address to be correct, she took no further steps. She confirmed, too, that she had had a conversation with Ms. Stevenson of Section 27, but never reverted. So the attempt to appeal to a party, a body, an independent institution of the department where the families were getting no joy was also fruitless.
I mean, that's a willful thwarting of a legislative purpose. The lawgiver goes out there and says, I will protect mental health care users by using a review board. It is constituted. Members take their money every month, and they never raise a finger to protect mental health care users.
It is, Justice, that it is exactly why the taxpayers have agreed to the appropriation of public funds for that purpose. But those public funds were squandered in this case. On 14 December 2015, Section 27's Ms. Rujeje sent an email for the Premier's attention. The Premier testified that he had not seen the letter that was sent to his office by Section 27. And he did confirm that the addressees were his staff, but that he'd never received the letter. And he denied knowledge of the 2015 litigation that then ensued. The National Department of Health was also warned about the project. Section 27 contacted the Director General of Health, Ms. Precious Masondo, and informed her of the risks in November 2015. Ms. Masondo did intervene and facilitated a settlement agreement between the parties, but she testified that she was under the impression that once the settlement agreement was signed, she did not have to intervene any further. So the families of the mental health care users made their concerns known repeatedly in various means, through meetings, protests, and even litigation. But protestation by the families was seen as a sign that the families were being influenced by others or that there was a political agenda at play.
Of course, this obvious and deep disregard, wanton disregard for all these pleas must have a play in equitable redress, isn't it?
We will be submitting that conduct not only goes to the violation of the breach of fundamental rights under Chapter 2, but it fundamentally undermines the principle of participatory democracy that is enshrined in Section 195 of the Constitution. And without the ability to rely on Section 195 as the mechanism to assert one's rights in Chapter 2, the members of the public are bereft. They're disempowered, they're disabled.
If you think about it, had just a family committee of family members been listened to, or at least their complaints investigated, the disaster would not have ensued.
That's true.
The timeous protest and screaming and that is set out in the heads, and they were ignored.
And all of those protests and shouts and even the December 2015 litigation came before the patients began, before the transfer of the mental health care users.
Yes, indeed.
Justice, it's almost 12 o'clock. Should I keep going for a few minutes?
No, you have 3 minutes.
I will use the 3 minutes.
If you go 3 minutes over, it won't harm anything, but that's fine. I think let's use that time and then take the break.
It's just to wrap up.
I know you're moving over now to the litigation.
That's right, Justice.
Maybe let's take the break now. That's fine. It's a good point to stop, and we can take it from there.
As your Justice pleases.
Okay. We are adjourned till 12:30.